The Fourth Amendment protects the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. It sounds broad and sweeping, but in practice the Supreme Court has spent over 150 years drawing lines about exactly what counts as a search, when a search is reasonable, and what happens when police violate these rules. The modern Fourth Amendment framework traces back to Katz v. United States in 1967, where the court held that the amendment protects people, not places, and established the reasonable expectation of privacy test. If you have a reasonable expectation of privacy in something, the government needs a warrant or a valid exception to search or seize it. This is legal education, not legal advice. Consult a licensed attorney for your specific situation. What does a reasonable expectation of privacy mean? The Katz test has two parts. First, did you subjectively expect privacy? Did you actually think the thing was private? Second, is that expectation one that society recognizes as reasonable? This is where courts draw lines. You have a reasonable expectation of privacy inside your home, in sealed containers, in your private communications. You do not have a reasonable expectation of privacy in things you voluntarily expose to the public. The third-party doctrine, established in Smith v. Maryland in 1979, holds that information you voluntarily share with a third party, like a phone company, loses Fourth Amendment protection because you took the risk that the company might share it with the government. The automobile exception is one of the most important Fourth Amendment rules for everyday Americans. In Carroll v. United States in 1925, the Supreme Court created an exception allowing warrantless searches of vehicles when police have probable cause to believe the vehicle contains evidence of a crime. The justification was the ready mobility of vehicles and the reduced expectation of privacy in a car on a public road. Courts have greatly expanded this exception over time. Police can search your car without a warrant if they have probable cause, not just a hunch, but articulable facts supporting a reasonable belief. Other major exceptions include consent searches, plain view seizures, exigent circumstances like hot pursuit, and searches incident to a lawful arrest. Carpenter v. United States in 2018 marked a dramatic shift in Fourth Amendment law. In a 5-4 decision, Chief Justice Roberts, writing for the majority, held that cell site location information, the records phone companies keep of which towers your phone pings, does receive Fourth Amendment protection, even though it is held by a third party. The court carved out an exception to the third-party doctrine for comprehensive digital surveillance that reveals the whole of a person's movements. This was a significant ruling because it suggested the old third-party doctrine might not fully apply to the modern digital world. However, the court left many questions unanswered about other types of digital data and the extent of this new protection. No-knock raids have become a flashpoint in Fourth Amendment litigation. Normally, police executing a search warrant must knock and announce their presence before entering. But courts recognize an exception when advance notice would allow evidence destruction or endanger officers. The no-knock exception has expanded significantly, and tragic cases like the death of Breonna Taylor in 2020 have renewed public debate about when these raids are appropriate. The Supreme Court in Hudson v. Michigan in 2006 held that violation of the knock-and-announce requirement does not trigger the exclusionary rule, meaning evidence found during a violation can still be used in court, which critics argue removes any real deterrent. The exclusionary rule is the main remedy for Fourth Amendment violations. Evidence obtained through an unconstitutional search or seizure is suppressed, meaning it cannot be used against you at trial. The fruit of the poisonous tree doctrine extends this to secondary evidence discovered because of the illegal search. But the exclusionary rule has significant exceptions. Inevitable discovery means evidence that would have been found anyway through legal means can be used. Independent source means evidence discovered through a separate, lawful investigation is admissible. Good faith means evidence gathered by police who reasonably relied on a technically invalid warrant can be used. These exceptions have significantly narrowed the rule's impact. This is legal education only. Please consult a licensed attorney for your specific situation.